Hello and welcome to the Hill and Ponton video blog. I'm Brian Hill here with Carol Ponton. Today we want to talk to you about the new system. It's called AMA. It's the new way that the VA has to appeal their cases, and we've seen some minefields, seen some problems in this system, and we want to give you some important information about it. So we'll be right back. Stay with us. Carol, I know that this is a new system, and frankly, it's a system where the information from the VA about the system has been slow coming out.
Yes.
And the VA is doing strange things. But what has been your experience with the AMA?
Well, I think exactly what you're saying. We go twice a year to the seminar, and while we're there, we have a chance to ask the VA how this works, and they are often unsure exactly how it works. And we know that the system is set up so that you have three ways you can appeal. You can actually go back and, as if it was a new claim, and file and ask them to look at the case all over again. You have to have new medical evidence. And then the second thing you can do is ask for a higher review. And both of these are at the regional office. Or you can ask to go to the Board of Veterans' Appeal. So first of all, you have the dilemma of which one do you choose?
Yeah, and assuming that you choose the one, the supplemental lane at the regional office, we're getting letters back from them that probably, generally when you get a decision by the VA, it's clear that it's a decision. It's clear because they tell you you have the right to appeal. But if you don't go into the supplemental lane right, all you get back from them is a letter saying you haven't done it right. You haven't given us any new evidence.
And what happens then?
And that's it.
What should they do?
If you don't respond to that, if you don't give them new evidence, and you let your year run, then your appeal time is over. So we spent years working in the old system, and we knew the tricks and we knew the different ways, but there's a whole lot of minefields in this new system that we're just not familiar with yet, and we're working through them. But it's very important that you understand what you're doing before you file these appeals.
Because that's exactly what we were seeing. We would file a supplemental, and then we would get a letter saying there's no additional evidence. Well, we figured, okay, we'll get evidence in there, but we didn't think that there's a timeline running. So even we were not, until we all talked about it, aware that this is an area that you need to be aware of. Don't just sit there and let your claim. What do you think they should do?
Well, I really think that the answer to that is that you need to have new evidence, and it's not just medical evidence. It can be as much as a statement by the veteran, as long as the statement provides new evidence that hasn't been in the file before. And you need to make sure that some new evidence is in the file to force.
So new evidence as to how it was service connected, if that's the issue,
right?
Or new evidence as to how your condition is much worse, if that's the issue,
right? Right. And that forces the VA to make a decision so that you have the right to appeal that decision. Our concern is that if you get this letter and just put it aside, you're going to lose your right to appeal.
Yes.
So that's the real issue here. And the other thing that we're concerned about is if you take the option of going to the board, there are some time frames there that we understand now are going to be strictly enforced by the board. In the past, we have been able to go to the Board of Veterans' Appeals in Washington and generally put evidence into the record up until the time that the board was ready to make a decision.
But you can't do that anymore.
Now that's not true.
You have three choices. One is that you have the board look at the case as it was before the regional office. That means you may add something, but they're not going to look at it. That's very important. So if you pick direct, here are your three choices: direct appeal, 90 days to submit evidence, or request for a hearing. So if you pick direct appeal, that means nothing that you send in after the decision was made at the regional office is going to be considered by the board. If you pick 90 days, you have only 90 days from when you file that appeal to get the evidence into the board. I would say about the hearing, when we were at the conference last, the head judge told us that if you ask for a hearing, you may wait a very long time. So we discourage people from asking for a hearing because of that.
Well, thank you for joining us today at the Hill and Ponton video blog, and we'll look forward to talking with you again.